Okay, just want to welcome everybody today to our presentation. We're very excited to have Rosenn, Jenkins, and Greenwald here to produce our seminar, which is Practice Tips for Properly Structuring and Conducting Effective Internal Corporate Investigations. So a very relevant topic. I know we're all excited to hear about it. Certainly we're also excited to hear from anyone on Facebook that is watching us. And this is part of our 101 series through our Wilkes-Barre Connect program at the Greater Wilkes-Barre Chamber. So this is an educational video series for anything that we can provide within the realm of business, and we're very excited that they're here today to do so. So I'd like to introduce our presenters, Paul Rushton, the chair of the firm's Business and Finance Department, James Valentine, the chair of the firm's Labor Department, and Michael Sowinski, a former Luzerne County Assistant District Attorney and a member of the firm's Litigation Department, to guide us through the program.
Good afternoon, or appreciate everyone coming who's actually here and everyone's listening live. Thought I'd take a minute just to explain a little bit about our law firm because it has a bearing on this presentation. We're coming up on our 65th anniversary of our firm, been around a long time, and the way we've structured our firm is that we have everyone specialized in a different area. As you heard, I'm the head of our Business and Finance Department. Jim Valentine's the head of our Labor Department, and Mike Sowinski's in our Litigation Department and has a few subspecialties in between there. So what we want to do, part of what we think makes us well served to sort of do these types of investigations is we have these different types of specialties. As we'll discuss throughout this presentation, there's different issues that come up as you start to tackle an investigation where you need people with specialties of these different areas, as well as some other areas that we'll talk about as well. So what I thought we'd do very briefly is just explain a little bit what our background is, each of us, and then we'll get right into the presentation. As Lindsay alluded to, I'm the head of our Business and Finance Department, and what I specialize mostly is in buying and selling businesses, setting up companies, negotiating contracts, and dealing with the policies and procedures and bylaws of the company. What leads me to be involved with a lot of these corporate investigations is, we'll talk about in depth and as part of this, is a lot of what you're trying to figure out is whether all those policies and procedures and bylaws and things were followed correctly, and having a proper understanding of the corporate structure and everything else helps lead to that conclusion. I'm going to have Jim Valentine come up and sort of explain what he does as part of his practice so that we can let you know what that is as well.
Thanks, Paul. Hello, everybody. My name's Jim Valentine. I head up our firm's Labor Department. In that capacity, I represent employers in all areas and phases of labor and employment law. What does that include? That includes representing employers and defending them before the Equal Employment Opportunity Commission, the Pennsylvania Human Relations Commission, the National Labor Relations Board, Pennsylvania Labor Relations Board. I also get involved in negotiations, collective bargaining with unions on behalf of employers, labor arbitrations, unemployment compensation proceedings. We also, in our group, get involved with drafting and reviewing personnel handbooks, which we'll talk a little bit about today in our presentation. And most of all, it's day-to-day talking to employers, guiding them through the myriad of issues and traps in the labor and employment law field. With that, I'm going to turn it over to Mike Sowinski.
Thank you, Jim. My name's Mike Sowinski, and I am in our firm's litigation department. Part of what I do is I handle commercial disputes amongst businesses, and prior to my time at Rosenn, Jenkins Greenwald, I was an assistant district attorney here in Luzerne County, where I was involved with investigations into thefts from businesses, nonprofits, families, et cetera. While at the district attorney's office, I received training from the National White Collar Crime Center in financial investigations and exploitation of elders in financial cases, and I was later cross-designated at the U.S. Attorney's Office as a special assistant prosecutor where I handled mortgage frauds. With that said, Paul will get us started in the presentation.
And Mike, most importantly, has a nice badge in his office from when he was an ADA, which we're all envious of. So, you know, he's got a lot going for himself. So we're going to jump into, let's talk about what are we talking about here? What are internal corporate investigations? What you're generally talking about with a corporate investigation is an investigation of alleged wrongdoing or other conduct You're determining the relevant facts relating to whatever's been alleged. You're then applying the applicable law and/or the governing documents to find out whether that applicable law and/or the governing documents have in fact been violated. And then ultimately, you're identifying, and we'll go through this a lot as part of this presentation, what you believe that the organization is required to do, whether by law or by their documents, and what you're recommending that they do. And we'll get into that in a lot more detail. What we've seen in the next several slides talk about is that there's reasons for a lot of increases in investigations in recent years. One of the big things that's coming out in recent years too is, and we'll talk about what some of those things are, we think that in the future and in the near future, investigations are going to become more and more commonplace, and we'll talk about why that's the case. One of the reasons that we've seen a lot, and I know that some of the people out there may be a party to it, but government regulation of several industries, most notably healthcare, securities, and governmental contractors, has led organizations in these industries to adopt compliance plans. The only way to deal with that level of regulation is to have compliance plans and a lot of procedures to deal with it. What those enhanced requirements have done, though, where there's a lot more rules, there's a lot more opportunity for people to break the rules. And so what ends up happening is people will come up with allegations that this, that, or the other policy or procedure hasn't been followed. That then leads the companies to decide whether they're required to or whether they voluntarily decide to investigate such potential violations of those rules. There's also been some other recent developments that have led to even more scrutiny and more decisions as to whether to do investigation. Most notably, the Sarbanes-Oxley Act, which was aimed at reducing accounting fraud with public companies. It came out as, you know, after Enron and what happened in 2008, everything else, it came out that what they wanted to do was create heightened requirements on officers, directors, and advisors of corporations, public ones, to identify material issues before issuing the financial statements. Financial statements are used for investors and others to decide whether to continue to invest in these companies or whether to sell and everything else. They want them to be true, so they created these heightened requirements. What that's then led to is even more internal investigations, and the auditors want to find out before they're issuing the financial statements, is there anything ongoing and do I need to make reference to it in the documents? So all of that has really led to even more corporate investigations. Finally, there's been a number of statutes and also some policies and procedures that have been created in companies which promote whistleblowing. The government wants the whistleblowing for certain activities so that this wrongdoing comes out. The policies and procedures, which Jim will get into in a moment, really try to encourage people to come forward, and that whistleblowing in turn has then led to more allegations, and that's then led to more decisions as to whether an internal corporate investigation should be conducted to find out whether those allegations are true. So Jim's going to come up and talk a little bit more about exactly what some of those policies and procedures are that have led to that result we just talked about.
One of the reasons that there are increased investigations at this time is because we have policy manuals at our companies that require that investigations take place if certain workplace conduct is in fact reported. The most important thing that you should know is that employers should have policies, should have handbooks in their workplace. Additionally, those policies should be distributed to the employees. I can't tell you the number of times I find that employers have policies but never distribute them to the employees. It's like it could be a mystery. So employers, always distribute your policies to your employees. Further, employers should get acknowledgement that the employees in fact received the policies. As indicated in the slide, there's reference to sexual harassment, that employers should have policies governing harassment in the workplace. They are not only strongly recommended, in my opinion, they're required. The various agencies would expect that an employer has a policy that prohibits harassment in the workplace, that requires an employer to investigate any complaints of harassment and to take prompt corrective remedial action immediately upon concluding its thorough and prompt investigation. One other thing about the handbooks is that if you do have a handbook, it should be updated and reviewed at a minimum every 2 years. Why? Because the law changes. And what good is an investigative process if it's referring to provisions in a law which have been altered or revised? So really, they should be reviewed internally and by counsel every 2 years. We've all heard of the Me Too movement, among other movements out there now, which are prompting individuals to make complaints about harassment in their workplaces. One of the issues that has come up as it pertains to doing an investigation, an employer may say, hey, Jim, we got this report of harassment from 3 years ago. Now, the statute of limitations has run. That individual can't file a charge at this time. It would be untimely to file that charge with a state or federal agency. So do we have to investigate this? Why would we have to investigate it if there's really no action that can be taken against us at this time? My response, investigate the complaint. Look into it, remedy it, address it with the individual. The last thing that the employer needs to have is a reputation that it does not address complaints of harassment or discrimination at any time when they are provided. Okay? Also, as noted, there's a potential for lawsuits, consumer boycotts. We've all seen those in the news, of products of an organization which is non-responsive to these complaints of harassment, discrimination, or any other type of workplace misconduct. Quite honestly, we've seen a real uptick in this sort of investigation. On behalf of clients, we do get involved in assisting them with their investigations. There are two types of investigations that, in fact, take place in the corporate sector. One which a corporation is required to undertake, and those which a corporation may voluntarily undertake. The ones where we're required to undergo an investigation, again, remember where I come from. I'm the labor lawyer. Clearly, these type of investigations are necessary when there's allegations of workplace misconduct. Again, our policy manual should set that forth. 2, we should adhere to our policy manual and conduct an investigation appropriately. Included in the packet which was distributed today, and which I understand for the online viewers will be made available at a later time, there is information from the Equal Employment Opportunity Commission as to what elements should be contained in an employer's sexual harassment policy. And quite frankly, when we speak of sexual harassment, we're speaking about harassment on all bases. Cannot harass on the basis of race, sex, creed, color, national origin, disability. Also in there in the packet is the EEOC's outline as to what they believe constitutes an effective investigation, and which is going to, quite frankly, mirror a lot which you're going to be hearing as we go along here today. Okay, so examples of required internal corporate investigations. Often, you'll receive a discovery request in litigation, a subpoena for documentation, which prompts you to obviously review all the information that you have and do your own investigation to be sure that you're complying in full with the investigation. An investigation required with a document request from a federal agency. For example, the Equal Employment Opportunity Commission may request information pertaining to all similarly situated employees, similar to the employee who's now raising a complaint. Been involved where there have been thousands of employees where that information has been requested about. Also, voluntary investigations on behalf of the employer. At times, you may want to investigate whether or not theft is occurring in the workplace, whether individuals are using your technology for appropriately work-related purposes as opposed to viewing inappropriate websites during work time. These are all different types of investigations that can take place. One of the things when we get involved in an investigation is we want to be conscious of the attorney-client privilege. Now, this subject in and of itself could take another hour, and I'm not going to spend much time on it at this point. We do attempt to have the investigations, in fact, preserve that attorney-client privilege. We point that out at the beginning, that we represent the client per se, and that we're doing this for legal investigation and analysis of the matter which they've brought to our attention. Please know that there are a lot of exceptions to the attorney-client privilege. For example, in a sexual harassment investigation, if you have a lawyer come in to do the investigation, and the employer is going to use the results of that investigation as a defense to a claim that they violated the law, that there was harassment, in a hostile work environment sort of claim, the attorney-client privilege no longer exists. The lawyer would have to turn over the information that he obtained during the course of that investigation. It would be subject to testifying and being deposed in that case. What does that mean? If you're going to have a lawyer who you're going to have do your investigation, it may be subject to all that. You want to be sure that you have a lawyer that knows what they're doing in this area of law. Mike's going to talk now about defamation and libel.
Thank you, Jim. In order for an internal corporate investigation to be effective, the investigator is going to make an opinion at the end of the investigation to determine what exactly happened and whether there was a wrongdoing that occurred. And at times, this can expose the investigator to a slander or a libel suit. So those individuals that are identified as having violated the law, company policy, or procedure, and if it's in an oral or written report concerning this investigation, this can trigger a claim against the investigator or the business from the person who's being accused of the wrongdoing. Such claims assert the facts or conclusions set forth in the report are false and thus defamatory or libelous. This presentation will identify several different steps that can be taken by an investigator to protect against the defamation or libel claims, and oftentimes an investigator will ask the client to indemnify or essentially stand in their shoes in the event such a claim occurs. And really what you need to be careful of during these investigations is who this report or the findings are ultimately disclosed to, because that's really what would trigger the libel or the slandered claim.
So what we're going to go over now is a few pre-investigative steps. Before you even get into the investigation, there's a number of key things that you have to figure out in order to properly structure the thing. And so what we normally say first is, where it's not one of those required instances that we talked about earlier where the law or your policies or something say you must do it, then it really becomes a business decision and sometimes a moral decision for the organization to say, okay, we've been confronted with an allegation or another potential investigative topic, and we've got to decide as a business whether or not to initiate an investigation concerning such allegation or topic. There's a lot of different factors that go into that sort of decision. Number one is these investigations are costly and time-consuming. So as an organization, you have to decide for yourself, okay, are we really willing to put in the requisite time, the requisite resources to do this properly? Because one of the worst things you could do is start an investigation and then not really do it correctly. So you got to decide, are we going to do it? The other thing that really comes up a lot in this context is people are worried that if they dig into something like anything else, you might find a very big problem. So on one hand, you want to make sure that, as an organization, we don't want these problems festering. On the other hand, you're like, if we dig further, we're going to create potentially a smoking gun that through discovery or other things could become available to litigants and everything else. And in those instances, we're going to be in a position where, especially if we're not prepared to go forward and do something about it, change what's going on within the organization, we might be in a worse shape than if we actually never investigated it. So, you can make your own decisions on what that might mean morally, depending on what it is, but that's what comes into the decision-making when you're going through a voluntary procedure. The next one is really, from our perspective, who's the client? That's how we always say it, but, from the standpoint of who is going to be the body or the representative to whom the investigator is going to report. There's been a decision made, we just went through it, yes, we're going to investigate. The next question is, okay, who is that investigator going to report to? What's the lines of communications and everything else? And it can be different people. Sometimes it's an entire board, especially where the organization is smaller. Let's say it's a smaller company with 3 or 4 people on the board. A lot of times you'll have it be the board. In other instances, an organization especially, can have a very, very large board. And what sometimes people decide is it's, number one, impractical, it's too unwieldy to have the entire board involved with that process, especially where there's outside directors. So in other words, the directors are not people that work within the organization, but rather they might be someone from a different organization that was brought in because they add a certain expertise to the board. In those instances, because you might want to keep the lid on the situation a little bit more until you know what it is, rather than have the entire board be the client that's reported to throughout the whole process, you might establish just a committee of the board that would be reported to, a much smaller subset of the board. You might have a standalone committee that's set up with certain select people that you think can be more judicious with the information, can keep it quiet or whatever else. Or sometimes you report to a solitary officer from the standpoint of trying to keep it very under wraps. And the criteria that sort of goes into making that decision is, who do we think we need involved with this decision as an organization to make a good choice? Who's prudent, who has the requisite skill sets to really analyze what the investigators come back with and make a decision? And secondly, do we want to keep this quiet? I mean, sometimes the subject matter of these investigations is potentially really explosive things, especially where, sometimes the chief executive officer or people very high up in the organization can be the ones that are accused. That sort of information, especially if it gets public, can be very damaging to the organization. So you want to make sure you investigate it properly and with the right people, but at the same time, people talk, and even within an organization, and you don't want gossip leading to disclosure and inadvertent disclosure of this information. The other thing that as we'll get into more later, is you're also, as you're adding people to this team that's going to have the investigation done, you want to make sure that you don't somehow blow the attorney-client privilege, which we talked about previously. The next thing after you've decided sort of exactly who's going to be reported to and what that team's going to look like, the management that's looking at the issue, the next question is, okay, well, what are the investigators? What's the investigative team going to be comprised of? In order to conduct an effective corporate investigation, you really have got to get a team that can deal with all the relevant issues. If it's, and we'll get into it in a minute, but if it's a very narrow scope, just a criminal matter, just a labor matter, Mike or Jim would handle it on their own. But as we will detail as we go along, there's certain instances where you want a really full team. And part of what we can do with our firm, as we mentioned earlier, with all the different subspecialties, is put together the right team to deal with all these issues, and then sometimes bring in some other people as well. I'm going to turn this over to Jim. If it really only relates to what Jim does, Jim's handled these on his own a lot of instances and could sort of speak to how that works.
Thanks, Paul. If the matter involves a workplace misconduct allegation, labor attorney or two from our firm gets involved at that time at the request of the client. That will also necessitate our interaction with those individuals at the company, predominantly their human resources department, to assist us in compiling all the necessary information, arranging for us to meet with all the appropriate witnesses, and to help us put together our information so that we can ultimately put together a report. Also, we find that often the allegations of workplace misconduct may lead us to obtain the services of other professions if necessary. For example, if it's something to do with employee theft, or we're trying to look through the books to see what's going on, if an employee is engaged in taking money or whatever, we may have accountants come in and assist us in that task. And back to Paul with respect to how he compiles the corporate team.
Yeah, so at first glance, you'd say, like, what's a corporate attorney involved with this investigation? In most instances, you know, I wouldn't have thought that we would even be involved. But a lot of what happens with these is that there's really detailed procedures set forth either in the corporate bylaws or in the policies and procedures or in the law, corporate law, that says a certain pecking order, a certain procedure needs to be followed to properly authorize these transactions. And where people try to circumvent that in certain instances, that can be the basis of an investigation in part, along with what Jim says, where, for example, someone's trying to use a particular vendor because they might have a relationship with them or they might be getting a benefit from that vendor. Whether that process by which they went to select the vendor circumvented the correct corporate procedure and circumvented the correct authority that they needed in order to do that, that can be a basis of part of the investigation. And so when you get into those detailed analysis of those rules and regulations and those corporate bylaws, you really need a corporate attorney in a lot of instances to help make sense of it, because we deal with it all the time. We draft them and everything else. It really helps the investigative team if there's someone who can look at that and try to figure that out. So at the outset, when you're trying to assemble your team, you know, Jim might look at it and say, you know, there's a lot of employee issues with this thing, whether they violated the handbook and everything else. But it really escalates to more of a corporate issue as well, in that it also could have been that they didn't follow the correct procedure, and we need to find out if they did. So in instances like that, Jim and I have worked together on the transaction, on the investigation rather, to find out whether the transaction in question with the vendor, for instance, is appropriate or not appropriate. And it really takes both of our skill sets to do it. As you're looking at the investigative team as well, at first glance, you might not think that it would involve criminal conduct. But there are instances, especially if we didn't see it at the outset, where all of a sudden we stumble upon some facts as part of our investigation. Remember, part of what you're investigating is, whether certain conduct and everything happened. But as you set out to investigate one issue, sometimes you stumble upon another one. A great example is you think somebody might have been doing something improper with the same situation we talked about, their interaction with a vendor, their interaction with someone else within the organization. You have an audit conducted with their computer, you search their computer, and all of a sudden you stumble upon, let's say, child pornography or something else illegal. In that instance, we all go running down the hall to find Mike Sowinski, and Mike will talk a little bit about that.
As Paul said, sometimes the investigation will lead to a potential criminal matter, and oftentimes it's a good idea to have a criminal lawyer involved to determine whether a crime occurred, and if so, what do you do about it? And really what that comes down to is whether or not that business has a duty to disclose that criminal conduct. And the answer to that really depends on the type of business that they're engaged in. If they have certain reporting requirements, maybe they're a mandatory reporter, and you stumble upon an abuse issue, then maybe that business is required to report that to law enforcement. Sometimes it comes up in the context of a theft case, and then the criminal lawyer can help determine whether or not a theft occurred, and if so, what to do about it. The other thing to consider is whether or not, if that business has professional licenses or obligations that require them to disclose criminal conduct. And in that case, The criminal lawyer can assist in making a decision about whether or not you need to disclose that, and if so, what's the best way to disclose that in a way that helps the client. So that way, that investigating body will look and say, you know, they stumbled upon this issue, they self-reported, and here's what they did to correct that issue. Also, within the scope of the investigation, you have a number of document sources or evidence sources that will ultimately become part of the investigation, whether it's a written document or in today's age where technology involved, company computers, cell phone, or other electronic devices. Sometimes it's a good idea to consult an IT professional in order to preserve that evidence. The last thing the business wants to be is in a situation where there was evidence that would have ultimately had bearing on whether or not this conduct occurred, and that evidence is later lost. The business could then come into spoliation sanctions in the event there was litigation down the road. And the other thing to be careful of is that IT professional, you have to be mindful of who's involved in the investigation, because as we've said throughout the presentation, you want to be mindful of that attorney-client privilege, and if you bring in a non-lawyer or someone outside of that initial team, that could waive the attorney-client privilege. So that's also something that we should be mindful of. With that said, Jim's going to take over for identifying the scope of the investigation.
So you've seen so far there's a lot of pre-investigative steps, a lot of things that have to be looked at when an investigation is to be undertaken. Prior to conducting the investigation, it's important that the precise scope of the investigation is clarified. We've heard a lot of that recently in the news, that some investigations go beyond the scope of what they're originally supposedly intended to do. That is done clearly between the lawyer and the client to be sure that their appropriate investigation is in fact being conducted. It's done by an engagement letter, that in fact the engagement letter which sets forth what the investigator is going to do. It also specifies, as we talked about earlier, the attorney-client privilege, in that we attempt to, in fact, clarify who we're doing the job for, who we're engaged to do the investigation for, and how we're going to report the results of that investigation. Again, the document will also specify that we're being called upon to do a legal analysis. So the investigation starts. What's one of the first things that we do when that starts is we compile documentation. We ask the employer to provide to us, the corporation to provide for us, any and all documentation which is relevant to the issue at hand, that which is being investigated. Once we get that documentation, that can be used for us to determine what laws, what regulations may be impacted concerning the conduct in question. One way to determine what information is out there is to interview the client to, in fact, find out what type of documentation they maintain, that they may have in their archives, and what we will need to see. Obviously, we recognize that no client or nobody really likes to go through tons of paper or tons of online things that they may have, because it can be tedious, it can be lengthy, but there's really no way to do this without going through that process. As we've often explained to clients, you want us to know if there's something out there or something that we should be concerned about prior to your opposition knowing what what's out there. So we always want to be sure that we have the opportunity to see everything that may be relevant to the investigation at hand. After we get the documentation, of course, that may really do additional requests for information that we trust that the client will assist with. We inventory that information so we can properly identify it during the course of the investigation. Another thing is that we normally require or request that management enlist the cooperation of its employees to assist in the gathering of this information. And this may be done by way of a confidential memorandum or communication with the employees to say that, you know, we're requesting this information and please assist in doing so, and that there should be prompt response. Mike's now going to address the dealing with witnesses.
So the next step in the investigation, after you've had an opportunity to review the documentary evidence, the next step is to start to make a plan for the rest of your investigation, which would include witness interviews. So at that point, it's up to the corporation and the investigative team to determine what the best way to conduct those interviews are. And truly, you want to do your homework first. You want to get a good handle on what the issues are, what the evidence shows, and then you can conduct a plan as to who you're going to interview. And some of the things to consider with this respect is, you know, who is the key witnesses, or who are the key witnesses? Who's the person who's the focus of or the target of the investigation, who may have committed the wrongdoing, and where are you going to conduct those interviews? These interviews, you want them to be done in a place that is comfortable to the parties, so that way you're most likely to elicit candid responses, and you also want to make sure you avoid unnecessary disruption at the company. It's generally recommended that 2 attorneys interview each witness, with one attorney asking the questions and the other attorney taking notes concerning the questions asked and answers. The use of these attorneys is, again, it's aimed at maintaining that confidentiality and that attorney-client privilege. This way, the attorneys can prevent themselves from later having a witness challenging the answers given during the interview. You don't want to get yourself into a situation where it's a he said, she said situation, and it's one person's word against the other. Finally, a memorandum memorializing the issues discussed in the interview should be promptly prepared, so that way it ensures the accuracy of the information in the memo. In today's day of body cams and things like that, you may ask, well, why don't you just record the interviews? And the answer to that is, again, we're trying to focus on maintaining the confidentiality. And if you did have an audio recording of the interview, that would most certainly be discoverable, where an attorney's mental impressions and notes are not necessarily discoverable. So that would be one advantage of having the attorneys do the investigation versus having a non-lawyer or having an audio recording of such an interview. And again, this is aimed at maintaining the privilege. Prior to the commencement of the interview, it's a good idea for the lawyer, the investigator, to provide the following warnings, if you will. The investigators make sure that the client, who the client is made clear for all the parties involved. So the attorneys will say that the client is the business and not the actual person who's being interviewed. And this helps avoid the argument that the investigators are representing the witness, which can lead to a claim of conflict of interest and a potential disqualification. So you don't want to do the interview and then have the witness later come forward and say, well, I only answered these questions the way I did was because I thought this attorney was representing me. You want to make clear up front who the client is. You want to show what the purpose of the interview is, and that's to obtain facts necessary to provide legal advice, again, to the client. And this assists in claiming protections of the attorney-client privilege. The interview is intended to be the subject of attorney-client privilege, so we're labeling the memorandum, the notes, to make sure that we're doing everything we can to maintain that attorney-client privilege. So that way down the road, that does not become a discoverable document or become a piece of evidence later used against the client. And then we make known that the client may waive such a privilege without the knowledge or the consent of the witness. Investigators should also advise the witnesses to keep confidential the issues discussed during the interview. And this is so that way, when you interview one person, that one employee doesn't go and tell the other employees, oh, by the way, I was interviewed regarding this, and kind of tip off everyone else to what's happening within the investigation. The investigator should provide the warnings to the witness to sign, the written statement concerning these warnings to clearly document that they were provided with those warnings that we just spoke of before. And that way the witness we can affirmatively show that the witness was advised of the warnings and they indicated that he or she understood such warnings. It's also generally preferable to advise the witness that they have a right to obtain separate counsel concerning the issues in question. And this again goes to show that that witness knows that the attorney is representing someone besides that person. The memorandum concerning the interview should include statements that the memorandum is protected by attorney-client privilege, it's attorney work product, and it was prepared in anticipation of litigation, and includes mental impressions of counsel. And this way, again, we're maintaining that attorney-client privilege. And by doing so, it just continues to bolster the argument that this is a document that was prepared by the lawyers for the lawyers, and that way it does not become a discoverable document down the road.
So as you're listening to this, if three letters come to mind, sort of CYA, that's what this is a lot about, right? You want to make sure throughout this whole process that you're taking the steps to make sure that as an investigator, you're not going to be questioned after the fact. Jim and Mike just talked about a lot of the different things that we take. You know, you want to make sure that you at least leave open the possibility you can preserve attorney-client privilege. You want to take the steps to make sure as you get with these witnesses and these different folks that they're not going to go back later and say, I didn't say that, and thus I'm charging you for, defamation or libel. You want to make sure you have all the documents. And so when you go through that whole procedure, all the steps that Jim and Mike went through, you're then able to say, okay, we've identified the relevant facts. We've also taken a look at all the relevant law and or the documentation we need, and applying those facts to the situation, we've come up with our conclusions. We've decided whether there's been wrongdoing, we've decided whether there's required actions that need to be taken, and we've come up with some practical solutions and or other suggestions that we recommend for the organization. So once you get to that stage, unfortunately, you're not done. The question is, okay, we speak to the client. We talked about earlier who the client's going to be. Am I talking to a whole board? Am I talking to a committee of the board? Am I talking to a special committee? Am I talking to one officer? And I say, we've figured out what we want to say. How do you want us to say it? Do you want us to put it in writing, or do you want us to just tell you orally? And there's a number of factors that come into that. So the benefits of having a written report are as follows. Especially if you've done it voluntarily, you've decided, listen, there's a value to our organization to find out exactly what happened here. And especially if it's something that might be widespread, it could be trained against, there could be ways to make sure it doesn't happen again. With a written report, clear understanding what that is, management can then use that to go around and say, listen, we've gotten this report, we're not making this up, and now we think we need to go forward, and they've said we need to train, we agree with that. Let's use it practically on a going forward basis and make sure that we improve our organization. Let's make sure this doesn't happen again, for lack of a better term. The other thing that it can do is, we talked about earlier, there can be a required investigation. The use of a written report can really be evidence that you did conduct the investigation as required by your policies or as required by the law. You'd want some written evidence that happened. Also, if the investigation was voluntary and you're going to use this as a means of proving to people that you've acted prudently, it might help stave off some sort of litigation. Or more importantly, we talked about earlier with consumer boycotts and everything else, if you've got a bad actor in your organization, and part of the reason you did the investigation was to make sure that if people were outraged by what's happened, you'll want to point out exactly what you did, the steps you followed to make sure that that you acted prudently, that you didn't sweep it under the rug, and that might help you avoid a consumer boycott. For instance, a good example is, Ohio State had these allegations about Urban Meyer. Urban Meyer wins a lot of football games, so probably they didn't want to do an investigation theoretically because it might lead to something that would put them out. But at the same time, they wanted to be in a situation where they proved to the public, which is a public institution, that they did the right steps, that they took the proper action, and that when they made a decision, that it was backed up by something. And so that's one reason why you might do it, is in addition to being required by law to do it or being required by your bylaws or anything else to do it, actually that you might use it as almost a shield to say, we've done the right steps and this is what we're basing it on. All the Penn State fans here would probably say it was a terrible decision. He should have been in for the whole year, but putting aside that, that's why they did it that way. And the other thing is, like we had mentioned, sometimes you have a policy or procedure that requires it. Or you might go to a government agency and say, we're making a voluntary disclosure here. We're going to give you this report, and that's going to be part of your evidence, part of your argument that you should be able to avoid prosecution and everything else. You have a well-written report. We've done the right thing. We've taken this seriously. We shouldn't be charged for, say, what one individual in our organization did. On the flip side, though, the disadvantage of a written report is the possibility that the report is going to confirm alleged wrongdoing and be used against the company through discovery and by a government agency, a private litigant, or even a shareholder of the company itself. In other words, it'll create a smoking gun. But by digging through this, you find something really bad, and then let's say it's not protected by the attorney-client privilege because one or more of the things that we recommended didn't happen, then you've got something out there that establishes the wrongdoing. And so that's sometimes why people don't have a written report. The other way a written report can be problematic is if company management is half-hearted in really going towards the investigation. If there's, if they say, yes, we'll do an investigation, but unless it's overwhelming, we're not going to do anything, and we might not do anything anyway because the person involved is just too much of a rainmaker. They're just too valuable to the organization. It's going to have to be darn near the worst thing in the world for us to take an action. You probably don't want something in your file that says the attorneys involved in this highly recommend that you terminate this individual, and then you have that report, you put it in your file, and you didn't do it. If you think that's where it's going, if you're company management, you're probably better off getting that advice from orally rather than in writing. And that's the last point. Having tangible evidence that you ignored attorney advice is really not the right step. If we decide we're going to do a written report, the written report itself has to have a lot of bells and whistles. It has to take a certain comprehensive approach in order to both be effective and also, for management and reading it and everything else, and to also be protective of the investigators. So what it will normally have is a listing of all the documentation and the other materials that were reviewed by the investigator in reaching their decision. You want to make clear in this thing that as the investigator, we took a comprehensive approach and we looked at all relevant factors. As the slide says, if you weren't provided with certain information, let's say that certain people wouldn't disclose the information despite your requesting of it and your client said move forward notwithstanding that, if there were certain things that the company said we're just not going to be able to give to you, it's just the way it is, or if they were lost or something else, to protect yourself and to make a clear picture with that report, you got to say, hey, listen, there were certain things that weren't provided to the team. You say it right in the report. You may even mention that some of that might lead to a different conclusion so that you're painting a very accurate picture. Because as we mentioned earlier, you don't want to be in a position where you're being sued for defamation and libel. You want to be fair. You want to paint as accurate a picture as possible. So if you weren't able to see something that you think might have been relevant, you say it in the report. You also list all the witnesses that were interviewed by the investigative team as part of the investigation. Mike went through all the steps you need to take with that. You say, here's the people we talked to. if any relevant witnesses didn't refuse to speak to you or you weren't given access to them for the same reason as the documents, the report should say so. Then you set forth a summary of the facts that were identified by the investigative team as part of the investigation. As we mentioned, that's a large part of what you're doing. First you're finding out all the relevant facts, you're finding the facts, and then you're applying the law and/or the relevant documents to those facts. You got to be very detailed in what you tell people you found. You want it to be so that it tells the entire story as you understand it, and anything that you think might have been, might have been unclear based on your investigation, you should say it's unclear. Then you go through in your report, you give a description of the conclusions you reached concerning the allegations, the investigative topics. You say, hey, listen, based on these facts, we've found that this, that, and the other law, or this, that, and the other policy and procedure was violated. And then from there, you say, listen, here's what we've concluded you have to do. Here's the required actions that we think you have to take, and here's the things that we recommend that you should take. We've looked at your policies and procedures. They're unclear on subjects A, B, and Z, which led to a bunch of problems here. We think that if you enhance these policies and procedures, this problem could be avoided. Or your structure, we talked about earlier how structure. You have people without a good check and balance in your organization. We recommend you change that so that we're not in a position where you're running into the same problem again. So you have required actions and then you have recommended actions, and that's all set out in your report. And then to better protect against those libel claims, which would come from a report like this, you want to be very professional. You don't want to be hyperbolic about this guy who we found to have committed this wrongdoing, put in personal things. We think he's the worst guy in the world, or all that sort of stuff isn't going to help anybody in this. It's got to be very professional. You also want to make very clear on what you base this all on. Because remember, whoever gets, especially if someone's found to have been wrongdoing, they're going to, if it's just blanket statements without backup for it, they're going to challenge it. They're less likely to challenge it if you say, we found that he's likely to have committed this wrongdoing based on A, B, and C. This witness said this, we found this document, he didn't follow this. So that it's not supposition, it's really based on clear facts. And then if, like I said earlier, if there's any question on things, if you've identified holes in your investigation that you can't close despite your request to do so, the report needs to make that very clear. And even say, listen, although we think it's more likely than not that he committed the alleged wrongdoing, we're concerned that these documents that we weren't able to review, or this witness that we weren't able to speak to might have come up with an alternative explanation for some of these things, and that should be kept in mind by the client in making their decision. And then finally, to make sure that you're in a situation where you're not going to blow your privilege, you don't want to share it with anyone other than the client. Jim's going to talk about a few more select issues, and then we have a little time for questions.
Very quickly, some industries are very highly regulated, and so if that's the case, it may be necessary to talk with counsel that specializes in that area to determine whether or not the results of the investigation have to be disclosed, or whether it's best to voluntarily disclose them. And that, as noted, is particularly true in the healthcare and in the security industries. I believe that is the last slide, and we are prepared to take questions should there be any.
Yes, I've got one. First, a very thorough presentation on the internal investigations. I think you guys did a really good job. Very thorough. But I do have a couple of questions for you. Maybe the first one to you, Jim. You had talked, getting back to your point on personal handbooks. Absolutely agree that they need to be handed out. I just wanted to know, do you think maybe even taking it to a further step? Should you have your employees, current employees, new employees sign off on those handbooks too? Just going back to Paul's point about making sure that you CYA yourself on that. Is that something that should be done relative to those handbooks?
The question is whether employees that receive handbooks and new employees receive handbooks should sign off as having acknowledged having received them. Yes, absolutely. An employer should make sure that every time they distribute a handbook and make any additional changes to the handbook or amendments to the handbook, that the employee signs off an acknowledgement stating that they did in fact receive it. Get plenty of calls where the employer says, well, this employee won't sign off. And the response to that is, well, take the acknowledgement sheet, indicate on there that the employee's refused to sign off, date it, put your initials down or your name down, and tuck that in the personnel file. And as far as I'm concerned, when it comes time for that unemployment compensation hearing or whatever, we'll have that in the file to establish that the employee in fact did get the handbook.
Paul, relative to your point about Sarbanes-Oxley Sox Compliance, as a follow-up to that, would you suggest that you formalize SOX compliance with all of your officers and employees for sign-offs on, it should you do it on a monthly basis, quarterly, but should you do it at all? Just curious.
Well, I mean, number one, you got to make sure you're subject to Sarbanes-Oxley, right? I mean, it's really, there's a limited amount of people that are, and if you're not going to want to follow exactly all those things because it's costly and it's difficult and everything else. You might voluntarily decide to do some things for the right reasons, but to be candid, Sarbanes-Oxley is a complicated field. We don't do a lot of it, and we would normally get someone with an expert that deals with it all the time because it's some heavy treading. It's definitely an area to be very concerned about.
So also, relative to identification of scope, what are the rules on jurisdiction when doing an investigation for companies that might be working in multiple states, you know, relative to federal, interstate versus state, interstate versus even municipal investigations and how they get adjudicated? Just curious how you would set up for that.
Yeah, so that just gets into, you know, all those pre-investigative steps that we talked about. You're trying to figure out, you know, in addition to all the documents you need and everything else, you're trying to find out what's the relevant laws. And so that's usually an interview with your client to find out what exactly they're subject to, because you need to know that because that might go towards all the required actions that you have. And so we go, what you described is where there's a lot of, companies involved with a lot of interstate commerce, maybe some commerce abroad and everything else. That just complicates it a lot. If they're sitting right in Wilkes-Barre every day, you're pretty sure you know what they're dealing with. But that it may not even be true sometimes with, you know, if it's an internet company and they're sending things all over the place, finding out what tax laws they're subject to and everything else. That's a lot of analysis, and it's an important analysis.
And then final question relative to corporate investigations. Can you maybe walk through some of the potential liabilities, say, between corporate officers and directors versus you know, exempt, non-exempt employees, and how you might want to make sure that you're doing the CYA steps?
Sure. No, I'll speak to the officer thing first and directors. So all directors and officers have fiduciary responsibility to the organization. So if they were to completely shirk these responsibilities, they could theoretically have liability. And, you know, as Matt could let you know, there's insurance available sometimes, but then there's exceptions to that insurance depending on what it has. There's D&O insurance for directors and officers, but it doesn't cover everything. And so that's all part of what we really preach to clients when they say, hey, listen, we've learned about this. Do you think we should do it? One of the factors that you say to them is you're probably obliged by your fiduciary duty to at least do something about it. And then finding the extent of that fiduciary responsibility and exactly where it ends, that's oftentimes a big part of what we're doing. As far as exempt and non-exempt?
Well, with respect to, well, I was going to go down the labor area, where in fact corporate liability of officers, directors, they're under the most of the federal discrimination laws. There's no individual liability. It's liability to the employer. But under the state, under the Pennsylvania Human Relations Act, which is similar to the laws which the EEOC has jurisdiction over, Pennsylvania Human Relations Act prohibits workplace discrimination on all the same protected classes. There can be individual liability under that law for individuals who violate it. So it's very concerning to individuals.
So think we're just about out of time. One more question from Matt?
Paul, thank you to Rosenn Jenkins bringing this to light, because it's very important issues you're bringing out that most businesses, smaller businesses at least, aren't aware of. Now, but my question, I'm glad you mentioned insurance, because management liability policies like the D&O policy, retail employment practices liability, and sexual harassment forms on nonprofits, they all have the requirement that immediate notice be given to the insurance company if they know that an incident has taken place that could arise to a claim. And when you have a claims-made policy and you change carriers and you don't have that retro date on there, you could get really nailed for the whole claim. So now, where time-wise, how would you fit into this situation if the insured is supposed to have already notified the insurance company? Or do you work as a representative for companies?
Well, so oftentimes what you talk about is another of the first things you talk about, because you don't want to blow your coverage, right? I mean, that's really what it's all about. And most insurance companies are pretty good that if you notify them about something that's alleged, but you don't know yet, and it turns out to not be anything, generally that doesn't affect your premiums as we understand it. So we generally recommend to people that they at least make them aware that there might be something there and that we're looking into it further. It's almost like just making sure that the delay in letting them know isn't going to blow it for you. The other thing that comes up a lot with insurance, Matt, is we found that some people's coverage even have a PR element to it, a public relations element to it, so that if one of these things turns into a scandal, occasionally their insurance even covers some of that. And so knowing, talking to the client about their insurance, and number one, making sure you don't blow the claim, but number two, making them aware of all the protections where it covers and where it doesn't, and what other things like public relations you might not think about is a big part of making sure you're doing your job. So that's another part of it. It really is. So guys, thanks so much. We enjoyed being in front of you, and thanks.
Thank you.